time you got it.
5:30. If y'all will bear with us, I'm told Ms. Miller should be joining us presently, so we'll give her just a moment. Hi there, Ms. Miller. Welcome. All righty. Welcome, Ms. Miller. All right. This special called meeting of the Lawrence City Council will now come to order. The time's 5:30. Quorum is present. Meeting's been published. Meeting agenda has two published items. Approval of the agenda and consideration of Ordinance 12-22-25. Before proceeding further, the chair notes that Councilmember Martin Lowry is requested to participate remotely for the purposes of attendance and voting. If there is no objection from the members present, given the short notice of this special called meeting and the fact that it is New Year's Eve, and given the extraordinary circumstances of this meeting and his request to be present, in the interest of ensuring full participation of council, the chair recognizes Council Member Lowry to appear remotely for this meeting. We'll begin tonight by an invocation, which will actually be led by Councilor Lowry, and then we'll follow that with the Pledge of Allegiance. Please stand if you're able.
Let us pray. Dear Heavenly Father, we come to you with heavy hearts. We come to you with a desire for guidance. We come to you to help, for you to help us come together as one council, to make decisions that are not only in the best interest of this city and its citizens, but are lawful and correct and respectful. We ask that you will give us clear minds to talk about issues as you see fit. We ask this in your name. Amen.
I pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. The next item on the agenda is opening remarks. I've prepared a statement that I want to share with you all. As we begin this meeting, I believe it's necessary to provide some clarity and transparency to the public regarding certain recent events and communications. Over the past 2 weeks, a group of council members have called two highly unusual special meetings, this being the second, one on December 23rd, just before Christmas, and now tonight on New Year's Eve, against the specific advice and recommendations of the city's independent legal counsel. On both occasions, a bare majority of council members appeared together at City Hall at the exact same time to sign a petition to call these meetings. No general invitation was sent to all members of council notifying them that a petition for a called meeting was proposed or inviting them to support such a petition. Yet, on two occasions, 4 members of council, a majority of council, which would constitute a quorum, arrived at exactly the same time, at exactly the same place, for exactly the same purpose, apparently having all reviewed a proposed agenda which had not been shared with all council members. In fact, initially when this matter was pursued, an agenda for a meeting which had not yet been properly called because it lacked the proper number of city councilors to request a meeting was sent to the press before it was even provided to me or other members of city council. Then, during the December 23rd meeting, there was confusion over which version of proposed ordinance or resolution was properly before the body because multiple drafts had apparently been circulated privately among only 4 council members without review by the city's legal counsel or remaining members of the body. Any member of the public is welcome to review the video footage of this meeting to confirm these facts. Yesterday, in a group text thread, which I began on Friday, November 28th, which is used only for official notices, one council member apparently mistakenly sent a text message and said, "What time would y'all like to meet?" That message, clearly intended for a separate private conversation, perhaps among another smaller group of city councilors, raises questions about whether council business or coordination is or has occurred outside publicly noticed meetings. The public has a right to expect that city council's decisions are being made in daylight and not through private channels or prearranged plans. This conduct raises serious ethical questions, which must be now investigated. Additionally, the public recently saw a document titled City of Lawrence Council Response to Legal Opinion, released on city letterhead without authorization. No individual city councilor may claim to speak for city council, for this body, unless specifically authorized to do so by the body. Nor may they use official branding in a way which would mislead the public. To members of the public, those here tonight and anyone watching, please be aware this response did not come from the city's administration, nor did it come from any lawfully appointed city attorney. It was not approved by this council as a body in any public meeting. The public should not be misled to believing that the document reflects an official position of the City of Lawrence. At least one member of council has demanded a retraction, and to my knowledge, no action has been taken by Ms. Sullivan, who sent this document to the press to correct the record. But this document raises a larger issue. Let me put this in the simplest terms possible. Either one counselor was acting improperly by attempting to speak for council when she did not, or she was speaking on behalf of other members of council who may have improperly conducted business in violation of the law. At our last special meeting, Councilor Miller read a statement and began her remarks claiming again to speak on behalf of the council. Councilor Miller's statement then compared the proposed ordinance to buying car insurance, suggesting it is simply precaution with no further implications or particular allegations of misconduct. I appreciate Ms. Miller confirming that this has nothing to do with any particular allegation against me and that all this is merely precautionary. I and the public should take her at her word, and I hope that helps quell some rumors, ridiculous rumors I might add, which have been spread on social media. However, car insurance does not transfer authority to drive from one policyholder to another. Car insurance doesn't override state law, and insurance doesn't upend the structure of government created by statute. The actions proposed in the ordinance before us tonight are not routine. They are not precautionary. They are not merely procedural. And according to the city's attorney on 2 separate occasions, they are not lawful. The public should clearly understand that the actions being pursued are in direct conflict with the written legal advice of the city's own attorney. Further, if this is simply about insurance, there is no urgency. There's no need for rushed, last-minute holiday meetings, no private drafting of multiple versions of ordinances, and no refusal to involve legal counsel in the process. You don't call emergency meetings on December 23rd and December 31st for a policy that's just a safeguard. I think the public has a right to question the frenzied and inexplicable actions which have taken place. If this is about transparency and accountability, then why all the secrecy and selective sharing of information? If this is about respect for the law and proper procedures, then why ignore the law? If this is about protecting taxpayer funds, why pursue a course of action which, if successful, we have been repeatedly warned would absolutely be very costly to the city, not only to council, not only to the city, but potentially to individual members of city council and their personal pocketbooks. If this is merely precautionary, why prioritize a rushed ordinance reshaping the administrative structure of the city government over second reading of a budget amendment, or even conversations about the financial feasibility of such an amendment, which would give city employees the overdue raises they were promised to begin in the new year? Why mislead city employees and tell them that the meeting on December 23rd was being called to consider these raises and not include a vote to approve them on the agenda? And I have heard the recording. It just doesn't add up. And I understand why the public would be just as frustrated as I have been that all of this doesn't add up. Let me be candid. I'm aware that all sorts of spurious allegations have been circulated by a disgruntled former employee. In normal circumstances, inflammatory statements by a former employee would be taken with a grain of salt. We consider the source. We consider the circumstances. However, it might be a bit concerning if there's more than one person making inflammatory statements. I understand that. But if those individuals did not come forward on their own accord, but instead at the request of one individual, that must be taken as highly suspect. It is important for council to be aware that this individual also reached out to multiple current and former city employees. But several have spoken to me and informed me they refused to sign statements supporting his allegations because they did not agree with the ridiculous claims being pushed. Still more troubling, current employees have actively sought to share their experiences with council and have not even been allowed to speak about the matters apparently being used to justify this ordinance. Why? Wouldn't they be in the best position to speak about the matters which might be of some concern to council and might be leading to this unprecedented action? Only listening to one side is not a pursuit of truth. That is pursuit of confirmation supporting a predetermined outcome. If anyone wonders why I question the ability of council to pursue a fair and impartial inquiry into any questions they may have, this is why. Even if every action outlined in the proposed ordinance were legal, and they are not, and even if it were properly introduced, and it wasn't, members of council must recognize that in addition to the issues I've raised, the optics of how this ordinance has been brought forward are terrible. A former election opponent of mine is leading the charge to weaken the office they failed to win at the ballot box. Secret allegations sourced from a disgruntled former employee given credence without giving either the mayor or staff the opportunity to respond. An ordinance crafted to weaponize those allegations before proper outside authorities have reviewed them. Circulating materials, information, drafts, proposed ordinances among certain members of council and not others, and specifically withholding information from other members of council and me. Apparently discussing confidential information learned in executive session regarding potential criminal misconduct with an individual who is the subject of that potential criminal ethical inquiry and investigation. Using legal provisions put in place to safeguard the public in cases of riots and wars to declare a public emergency by resolution, but not specifying how the public is in any immediate danger. Apparently communicating among at least 4 members of council in some form about city business outside of a called meeting, coordinating action so that all arrive at the exact same time at City Hall to demand a called meeting. Scheduling 2 called meetings on short notice to take place when city offices are closed for the Christmas and New Year's holidays, despite knowing that all members of council were not available and despite specific requests from both a member of council and legal counsel to schedule meetings at a more reasonable date. Put simply, it looks bad. I'm not drawing any conclusions from the facts I've outlined, but they illustrate and underscore the need to handle appropriate inquiries by an appropriate arm's length state-level entity. If it is determined that misconduct has occurred, that determination must not be tainted by what would very easily and likely be perceived as a politically tainted process. Several of these matters warrant further inquiry, and I can assure the public that will happen. Let me be clear about something else. My conscience is clear. While I am not perfect, and while I am sure I have made errors over the past 6 years, just as any human being sitting in my seat would, I have not engaged in any criminal misconduct. To my knowledge, none has been alleged, and I do not believe I've engaged in any unethical conduct. But I'm not afraid of any impartial inquiry. Bring it on. And because I'm not afraid of it, on Monday, just as I represented the council that I would, I requested that the chief of police provide any and all materials in our possession related to any allegations against me or any other city official be sent to SLED and, if appropriate, the Ethics Commission. Let that clear up another misconception I've heard. No ordinance such as the one proposed tonight was needed to do that. It's already in motion. Further, any inquiry should consider the full context and review all improprieties, including but not limited to the activities I've outlined here tonight. I believe that it's important to note that while I have welcomed impartial scrutiny by any appropriate lawful investigative body, the former employee who's made allegations against me and others is himself the subject of serious allegations, including the mass deletion of all public records which were stored on his City OneDrive. Let me reiterate. I have already requested referrals to SLED and, if appropriate, the Ethics Commission. That process is already underway. No ordinance is required. No restructuring of government is necessary. No seizure of authority is lawful. I also feel compelled to address an aspect of my recent behavior that I'm aware some have interpreted incorrectly. For the past several weeks, I've chosen to remain relatively silent, not because I lacked a response, and not because I have anything to hide. I remain quiet because ongoing inquiries can be influenced and compromised by public argument, and because city personnel issues are just generally not something we discuss in a public forum, ever. Especially when doing so would call attention to the shortcomings or difficulties of any former employee who may actively be seeking new employment. That's the standard I have respected for every employee, even those who have not shown the same courtesy to me or others. I also remain quiet because my faith teaches me to act with grace, not hostility, to de-escalate, not inflame, to avoid fanning the flames of gossip. But my silence should not be confused with shame, and my restraint should not be mistaken for guilt. The truth is this: nothing would be more satisfying to me than to broadcast my side of the story and seek vindication by airing my grievances. Who wouldn't enjoy that? But my conscience dictates that I must let the appropriate authorities conduct their appropriate inquiries rather than attempting to try anyone in the court of public opinion. With that said, when transparency and accountability and justice demand that public disclosure take place, when there are questions raising questions about public confidence in the city's administration and city functions, I have and I will share whatever information is necessary to the best of my ability in keeping with the dictates of my conscience. My effort to avoid publicly criticizing my colleagues on council should also not be misread to mean that I have no concerns about where we are and how we arrived here, particularly those actions which have taken place between December 22nd and today. I am deeply troubled by the conduct of certain members, particularly the refusal to return my calls and respond to messages offering to provide whatever information they needed, the choice to act without communicating with me or current staff to understand the facts, the needs, or the consequences of their actions. Decisions are being made and actions are being taken which have already disrupted city operations without even a basic attempt to learn how they'll affect employees, operations, or the public. That's not sound governance. That's carelessness. There's been no serious attempt to speak to the people actually running the departments this proposed ordinance would disrupt. None. No attempt to understand the impact on the workforce who are now fearful and destabilized by what they have informed me they perceive as political games instead of leadership. No preparation, no due diligence, and no responsible effort to understand what is being broken before breaking it. So now, after weeks of refusal to engage and refusal to learn the facts, at least a complete view of the facts, some members have arrived tonight anxious to take extreme, unlawful action. This ordinance does not reflect good governance. It reflects an attempt to replace the permanent legal structure of our government with the feelings of the moment. My silence was an act of discipline, but tonight it cannot be mistaken for consent. With that said, I am not here to point fingers. I'm here to point to the law. Council members can choose right now to conduct the business of this city with civility and respect, to engage in constructive communication rather than secretive plots, and to respect the rule of law. Every member of this body took an oath to uphold state law and our municipal code. That oath is not suspended for the holidays, political frustration, or any personal ambition. If there are genuine concerns, call me up. Let's sit down together and talk about what's on your mind. If there truly has been inappropriate conduct by any current or former members of city staff or any elected official, including myself, there are lawful processes in place under state law, administered by neutral state authorities, not by a temporary majority asserting power that does not belong to it. If members of council have questions about the independence of the judgment and legal guidance of our city attorney, let me address that matter head on. On September 19th, 2023, City Council voted as a body to retain Pope Flynn as the city's legal counsel. I did not select them. They responded to a request for qualifications, which was publicly noticed. They do not represent me. They do not represent City Council. They represent the city as a whole. When this ordinance and the associated resolution were first proposed, I immediately forwarded it to council for their review, legal counsel that is, for their review, and did not give them any instruction as to what the outcome of their review should be. I have no pre-existing relationship with Pope Flynn, either professional or personal, with any member of Pope Flynn, and they are a highly respected firm which practices primarily in the area of local government representation, an area, I might add, which most attorneys have very limited knowledge or experience. They are some of the best legal minds in our state, particularly in this unique and somewhat specialized field of legal practice. They also represent the city of Clinton and Lawrence County. Council has relied on their guidance for every matter which has required their professional opinion without exception since they were first lawfully appointed by a vote of this body. until now. Until legal counsel pushed back and respectfully advised City Council that the action proposed in this ordinance were an unlawful attempt to limit the statutory authority of my office. Pope Flynn is the city's own legal counsel. And fellow members of council, your own legal counsel has warned you in writing that this ordinance exceeds council's lawful authority, is not a lawful emergency ordinance, did not follow proper procedure, and exposes members of this council to personal financial liability for acting outside the scope of their power. After that warning, any action to continue seeking approval of this ordinance is a choice, and that choice carries consequences. The first would be that the city attorney would resign from their appointed position because they have advised us they can't advise a client who refuses to take their advice. To lose the benefits of their wealth of knowledge and experience would not only be a loss of helpful expertise to guide the city council in doing their business, it would be a further embarrassment to this city and a shameful display of arrogance to simply assert that we think we know better. There are some issues about which well-informed legal minds and particular expertise in municipal law may differ. But the legality of this AI-generated ordinance is not one of them. I don't know of any attorney in this state who would sign their name to that document. And I can say right now as an attorney myself, any lawyer who would is not giving sound legal advice. My interest in speaking against the actions of certain council members and this proposed ordinance is not self-preservation or some attempt to evade accountability. I stringently deny any wrongdoing, but I have already asked that independent authority conduct proper inquiries to confirm that or determine that. Instead, my interest is the protection of the city's legal and financial interest and our most important asset, our employees. If this ordinance were to be approved, it would harm the city in ways that are very predictable and very preventable. A declaratory judgment action will be required, costing taxpayers thousands of dollars to confirm what council has already said twice. Even in the unlikely event this ordinance were to be upheld, it calls for audits and independent reviews that would cost up to $500,000, only to produce findings with no binding effect on the agencies that actually have jurisdiction. That was the price tag faced by one of our neighboring cities for just this sort of thing. Staff morale will continue to suffer. Good employees will leave. I can tell you we already have staff questioning whether it's worth it to stay in the city when they do not feel they have the support of their own city council. Prospective investors and partners will look at Laurens and see instability. I'm already fielding questions dealing with the uncertainty regarding major investments due to this proposed ordinance. And if this is struck down, the cost will not be abstract. Someone will pay it. There's an absolute certainty that the city will face legal fees, and if the ordinance is struck down, individual members of council would also be affected. We can't light procedural fires and ignore the consequences and cost of putting them out. I'm urging that the proper thing to do is err on the side of caution. However, I'm not saying that any legitimate concerns about former city administrator, me, or anyone else be ignored. If there are concerns about the way I've conducted myself, or concerns about how any future mayor might conduct themselves, there are already laws in place to address that conduct. This insurance is not necessary. There are already budgetary oversight measures to ensure that purchases above $1,000 don't occur without proper authorization, and city accounts require multiple signatures on checks. Following the departure of the former city administrator, I immediately took steps and issued executive directives to ensure greater transparency and better communication among city staff. Not just about finances, but about all city business. I put in writing that no staff member need fear retribution simply because they shared information with the mayor which might help me carry out my duties. Rather than filtering information, siloing departments, and directly contradictory directives, I have been proud to see a new positive spirit of teamwork, professionalism, and camaraderie that would make council and every resident of this city proud. And perhaps, more to the point of the matters which have been raised by council, there are state agencies with appropriate jurisdiction to take lawful action and conduct investigations which can be done using state-appropriated funds in a way that doesn't place an unnecessary burden on city taxpayers and jeopardize the affordability of much-needed staff pay increases. There are statutes that define removal, investigation, and oversight. But that authority is limited to the authority of the governor, not this council. There is a lawful path to address every priority that council members have raised, but this ordinance is not it. If, after lawful, impartial investigation is determined that concerns about any one of us are unfounded, then choosing caution harms no one. We haven't violated the law. We haven't bankrupted the city. But if council throws caution to the wind and adopts an unlawful ordinance, it will have consequences. It is having consequences, legal, financial, and institutional. It's not the outcome I oppose. It's the method. This process has already been destructive. And I fear what has already occurred will drive away employees, partnerships, and opportunities that Lawrence can't afford to lose. And pursuing this matter further will absolutely be costly, whether in the courtroom, in the budget, or in the trust the public loses watching this debacle unfold. Not to mention the breakdown in relationships which have been built on this council to work together toward the common good, some of which have been formed over decades. The safest path is also the lawful path. It leads to an opportunity for communication and understanding and reconciliation, and yes, if appropriate, justice. Tonight, I intend to ensure that any action taken by this body complies with the law, respects the structure of our government, maintains transparency, protects the public, and upholds the oath we all swore. You may not all agree with me, but I will uphold the law and the proper order of this body. And I believe the people of Lawrence deserve nothing less. Thank you. I appreciate council's attention and patience in allowing me to make that statement. I believe that there are matters that just need to be cleared up for the public. Before considering the agenda, the chair is obligated under Section 2-74 of the Lawrence Code to preserve order and ensure compliance with state law and our municipal code of laws. The chair also invokes Section 2-73, which grants the presiding officer the right to speak on points of order. Under these provisions, the chair now raises a point of order regarding the ordinance listed. Under Section 2-93 of the City Code, no proposed ordinance may be introduced or considered unless it is approved in writing by the city attorney prior to introduction. That is not optional language. It is a procedural requirement and a condition precedent. Ordinance 12-22-25 does not meet this requirement. The city attorney issued written correspondence on December 23rd and again on December 30th, stating that he does not approve this ordinance, that it contains significant legal defects, and that its adoption would likely expose the city and individual council members to legal and financial liability. The city attorney stated that proceeding would exceed the statutory authority of council and warned that doing so may force forfeiture of legal representation. I have provided a copy of these legal opinions of the city's attorney for inclusion in the official minutes of this meeting and the city's permanent records. And at this time, I would ask that council members pass copies of statement I provided for the record for the clerk to place in the record. Because the ordinance was not approved, it was never validly introduced. Under Section 2-93, it is therefore not properly before council, cannot be placed on the agenda for action, and cannot lawfully proceed to a second reading.
Point of order, council has the authority under, let me get my section out, to propose ordinances. We can accept legal aid, but we don't have to, let me find it. We don't have to, go along with the recommendations. So I make a motion that we proceed with the agenda.
Ms. Sullivan, your point of order is out of order. I would direct you to Section 2-93 of the City Code. You may introduce ordinances,
Yes.
but it must be approved by the city attorney. That's the plain language that's been provided to you in what I handed down.
Yes, and the city attorney was here on the first reading, and we proceeded with the first reading, and she did not vote it down or use any specific language that we could move forward. So, my point of order raised questions about council's.
Ms. Sullivan, with all due respect, you're engaging in a debate. I have authority as chair
Yes, sir.
to decide points of order. The matter is decided.
The matter is decided, however, we still have a right to vote on second reading.
No, ma'am, you did not.
Yes, we do.
That is the ruling of the chair. The ordinance is not properly before council because it does not meet the basic requirements of an ordinance under Section 2-93.
It does. It does, yes, sir. it
Can you
does.
provide any indication the city attorney provided authorization and approval of the ordinance?
The first reading was passed, sir.
I've spoke with the city attorney about this last night, and he confirmed my understanding.
Yes, sir, and we have a right to have outside legal counsel. We have a right to,
Ms. Sullivan, you're out of order. This is your final warning.
yes, sir.
Thank you. There being no lawful business properly before this body, the only matter we have before us would be approval of the agenda, but the agenda needs to be approved as amended, striking ordinance 12-22-25.
Point of order.
Yes, Ms. Sullivan.
Point of order, sir. We would like for you to move forward with allowing us our rights to pass the second reading of this ordinance.
Ms. Sullivan, that's not a proper point of order. A decision has been made and rolled on by the chair under our ordinances.
You
It is not appropriate.
Yeah, you ruled the decision, but we have a right to appeal.
No proper appeal was made.
I make a motion that we appeal the ruling of the chair.
All right. If a appeal is made, the proper statement is, I appeal the decision of the chair. Under
Yes.
Section 2-75, an appeal must be decided without debate, and the question put shall be, shall the decision of the chair stand? This is not a vote on the ordinance, and only a vote on whether we follow our own municipal code. The question before council is whether or not we have received approval of the city attorney of this ordinance as required by Section 2-93, which is a condition precedent before city council may properly vote on any ordinance. That is the question. Ms. Sullivan, you have appealed the decision of the chair. I now therefore call the question, shall the decision of the chair stand?
No.
Mr. Bolt? No. Mr. Whitmer?
Repeat that again, please. Repeat what
Shall you, shall my decision
stand?
stand?
Yes, your decision.
No, you said no, I say no.
I say,
You-
okay, I misunderstood. Yes, your decision stands.
Okay.
Mr. Bolt votes to uphold the ruling of the chair. Mr. Lowry?
Yes, absolutely.
Mr. Lowry votes to uphold the decision of the chair. Mr. Whitmire?
No.
Mr. Whitmire votes to appeal the decision. Ms. Campbell?
No.
Ms. Campbell votes to appeal. Ms. Sullivan?
No.
Ms. Sullivan votes no. Ms. Miller?
No.
Ms. Miller votes no.
Can we have a motion?
The,
to accept the
if, the-
agenda? I'm sorry.
Ms. Sullivan, I'm chair of the meeting,
Go ahead.
with due respect. Council having appealed the decision, we move on to the next item of business, which would be approval of the items on the consent agenda. I object to these matters being approved
Can you read the motion?
together.
Point of order? Can you read the motion?
Ms. Sullivan, I can run this
Okay.
meeting.
Okay,
Thank you.
thank you.
There are two items before us on the consent agenda: approval of special called council agenda for tonight, and approval on second reading of the ordinance 12-22-25. Both of these items are included on the consent agenda. Consent agenda items will be discussed separately if there's a request from any member to discuss them separately, and I do so request. So the first item before us would be approval of the agenda for tonight's meeting. Do I hear any motions concerning approval of the agenda?
Second,
It needs to be a motion first, Ms. Sullivan.
okay,
I motion.
There's a motion. Is there a second?
second.
There's a motion and a second. All those in favor of approval of tonight's agenda, please indicate by saying aye.
Aye.
Any opposed, no?
No,
No.
No.
it's unlawful, no.
It's not unlawful.
No.
The next item before, having received a majority of votes of council, the agenda is approved. The next item before us would be what is captioned approval on second reading ordinance 12-22-25.
I make a motion that we approve, second reading of ordinance 12-22-25.
We have a motion. Is there a second? There's a second. For the record, please let the record reflect that the motion was made by Ms. Sullivan and seconded by Ms. Miller. Having a motion and a second, is there any discussion?
It is.
Chair recognizes Ms. Sullivan.
All right, let me get my information out. First thing I want to address is, and I want this to be added to the minutes. The city council acknowledges that it has received written allegations.
Point of order, Ms. Sullivan. You do not have the authority to speak for city council.
I'm a member of city council, and I received, along with the other members, and we acknowledge that we received written allegation raising concerns related to potential misuse of public funds, nepotism, harassment, and conflicts of interest within the executive administration of the city of Lawrence. City council makes no findings of fact at this time and recognizes that all parties are entitled to due process. In fulfillment of its fiduciary duty to the citizens of Lawrence and its obligation to ensure lawful and continuous operation of municipal government, City Council has determined that the appropriate next step include formally referring all information and documentation to the South Carolina Law Enforcement Division, SLED, and South Carolina Ethics Commission for independent review, as these matters fall outside the investigatory role of City Council. City Council further states for the record that it has voted to discontinue representation by the city's current legal counsel.
Point of order, Ms. Sullivan. No vote has taken place
Okay.
voting to terminate any representation.
I misread that. City Council further states for the record that the attorney stated that he would discontinue representation of the City Council as current legal with the passing of the second reading of this ordinance. This decision is based on concerns related to responsiveness, scope of representation, and the need to ensure independent and impartial legal guidance for the governing body during this process. Council affirms its intent to honor all contractor obligation once the legal services contract is received and reviewed for payment terms and outstanding responsibilities.
Ms. Sullivan, point of order
Point of
again.
order.
You do not have the ability to speak for council.
I have the ability to speak as a city council member.
As an individual city councilor, yes, you do.
Okay,
Point of order, then quit speaking for me.
I'm not speaking for you, Mr. Lowry, and happy,
If you're speaking for
New Year's
council,
Eve.
I'm on council, you're speaking for me, point of order. Quit calling it the council, because it's not the council, it's you.
Stay on point.
okay. The city council members, myself, you, Ms. Miller? Yes. You, Ms. Cassandra? You, Calvin? Mr. Mayor? Mr. Bolt? Mr. Lowry? Okay. No response has received. Council further, the ones that I just noted, notes that following submission of allegations, repeated attempts were made by members of council to seek legal guidance on behalf of the governing body as a whole. Council expresses concern that responses received did not adequately address the full scope of council's requests and appeared to be directed toward only one portion of the governing body rather than the council collectively. Selected city council members emphasizes that the action taken this evening are not disciplinary in nature, are not a determination of wrongdoing, and are not intended to prejudice any individual. Rather, these actions are taken to restore stability, protect employees, preserve public trust, address reports of internal and external workplace concerns, including allegation of hostile work environments, in a manner consistent with law and ethical governance. The selected city council member affirms its commitment to upholding the oath of the office taken by each elected official and to govern in a manner that promotes transparency, accountability, respect, and dignity for all citizens of Lawrence. The selected council members respectfully request the continued support and patience of the public as these matters proceed through the appropriate legal ethical review processes. The selected city council members further affirms that due process requires that all parties be afforded an opportunity to speak or respond through proper and professional channels. And council will refrain from further comment so as not to interfere with any review of investigation. This statement was from Ms. Marion Miller, but I read it for her. And
Thank you, Ms. Sullivan. Is there any further discussion?
yes, have more discussion. As it relates to this ordinance, we also have we put in place a civility, non-retaliation type of policy. And it governs us in here and out here and on the outside. And the selected city council reaffirmed its commitment to professionalism, civility, and mutual respect in accordance with the civility resolution previously adopted for the protection of all council members, city employees, and the public. Selected city council notes that concerns have been brought to its attention regarding the circulation of information that may constitute a smearing or retaliatory campaign directed toward a city council member. Council emphasizes that it does not engage in speculation and makes no finding regarding the source of intent of such information. Selected council member affirms that retaliation, harassment, or intimidation directed at any council member or city employee for carrying out their sworn duties will not be tolerated. Should information be presented indicating that such conduct originates from an individual identified as a constituent, council will address the matter consistent with the civility resolution, because we all voted on that, and take appropriate steps to ensure the safety, dignity, and lawful functioning of the governing body. The entire council that voted on the civility policy further clarifies that if any person possesses factual information suggesting that a council member or a city employee has engaged in criminal or unethical conduct, the proper course of action is to submit such information through established channels, including notification to council and the accused party, and filing of appropriate documentation with the relevant investigation authorities. Council remains committed to transparency, due process, and respectful exchange of ideas, and will continue to uphold its oath to serve the citizens of Lawrence without fear of retaliation. And I have one more statement.
Ms. Sullivan, you have been heard twice on this matter under our ordinances. That is your limit. Is there any further discussion from any other member of council?
It is.
Point of order, she's had 2 times.
Point of order, Ms. Miller is getting her information prepared.
Chair gladly recognize Ms. Miller when she's prepared. Is there any, while she is preparing her remarks, is there anybody else wishes to address council?
Council also acknowledged the broad service of statement of council sentiment. Excuse me. Council also acknowledged the prior service of Attorney Thompson, whose familiarity with the city of Lawrence and experience of municipality matters provide value, continuity, and institutional knowledge. Should Attorney Thompson be willing and available, council would prayerfully welcome the opportunity to explore his return of participation in serving the city, consistent with applicable procedures and agreements.
I too have a statement for the record. Employee compensation review. Members of the City Council affirm its intent to move forward addressing employee compensation as part of the upcoming budget cycle. Council is currently
Ms. Campbell,
reviewing.
I don't mean to interrupt you, but debate is only on the ordinance before us, and compensation of city employees is not part of anything pertaining to that ordinance. So we need to limit debate to the matter before us.
Okay. Members of the council notes for the record that on Tuesday, September 19th, 2023, council approved the appointment of Attorney Lawrence E. Flynn III to provide legal services to the city on an as-needed basis, with compensation structured at a variable rate rather than a fixed salary. Council further notes that this meeting represented the first occasion on which the council members had direct interaction with Mr. Flynn or were made aware of his appointment as city attorney. Mr. Flynn's professional focus is understood to be public finance and bond-related matters. In subsequent months, council has interacted with attorney Virginia Bozeman, who also serves as senior counsel with Pope Flynn Incorporated, and also specializes in governmental law. Council has met with Ms. Bozeman on a limited amount of times and has requested legal guidance at various times. At this time, council has not received confirmation of the full cost structure associated with current legal services, despite council's statutory responsibility to approve the municipal budget. Council expresses concerns that access to consistent legal counsel for the full governing body has been limited. Accordingly, council is reviewing the structure, cost, and accessibility of municipal legal services to ensure that legal counsel is available to the entire council body, supports transparent governance, and aligns with the city's fiscal responsibilities and stated values. If you would submit that, please.
Put your name on it, sign it. And put the date.
Is there any further discussion?
Yes.
Mr. Lowry. Chair recognizes Councilor Lowry.
I wish I could be there with you. Unfortunately, had previous plans that were made many times ago.
Point of
It's
order,
unfortunate because
point of order, that's not pertaining to the ordinance.
Well, your point of order is I'm fixing to talk, you could give me at least a complete sentence.
Please proceed, Councilor Lowry.
I'm sorry I can't be there. We've never, ever had a meeting at Christmas
Point of
time.
order is not about the ordinance.
It's about the agenda. The date of the agenda. It's on the agenda, the date that you put on there. This ordinance is unlawful. It's sad. It's sad that we've come to this on an ordinance to try to make the city look bad. That because some people lost an election and having a beef with the mayor.
Point of order,
You want to.
point of order, that's
Ms.
personal.
Sullivan,
It's unlawful.
Point of order.
one,
It's not point of order, I'm talking about the ordinance. that you
You're
put
not.
together.
one moment.
It's unlawful.
One moment. Councilor,
Unlawful.
Councilor Lowry, Ms. Sullivan, let's be respectful of each other.
I don't think that's in the nature, but if it didn't, that's fine. This ordinance is illegal. There's no doubt about it. You're opening up the city to some financial ramifications, that honestly, I don't want to pay for. I'm a citizen. I am someone who pays taxes, just like the rest of you. And to spend money on a witch hunt for this ordinance is ridiculous. I don't know what happened when we passed, the other things in November. I don't know what happened between then. I think I know. In fact, I do know. It's unfortunate that you don't want to believe what Nathan is offering, what our city attorney is offering, to give you all the information you want. But no, you'd rather come to this body and make us all look like a bunch of fools. Well, you're making some people look like fools. And it's awful. It's absolutely awful. It's disrespectful. And you want to talk about the city employees and a toxic environment or whatever else. How many of you have met with the employees? How many of you have met with them? I know how many. None. Because I did. I met with them. I talked to them. I asked them, is there a problem? No. Everything is better than it was. But none of y'all won't even hear from them. You don't even respect our own employees. To be able to go and have a one-on-one, face-to-face conversation. Well, guess what? I did. I did the work. I didn't do the throwing mud. I did the work. So why don't you do the work and go talk to some people? Why don't you do the work and get the information from Nathan? Why don't you do the work and get the information from the lawyer? Instead, you want to pass an ordinance that is not lawful, that is opening yourselves up for some serious stuff. You don't believe it,
Point
but
of
you will.
order.
But you will.
Point of order.
Point of
Miss-
order, my ass. Shut up.
hold on, hold on.
That's it, you gotta shut that down.
Mr. Lowry,
You gotta shut it down.
Mr. Lowry,
Man,
you are out of order. Ms. Sullivan, you are, just one moment. Ms. Sullivan, you are also out of order.
Shut your mouth.
Counselor Lowry,
That's my last. I want to.
we need to preserve the dignity of this body. And I'm saying that to all members of council.
Stay on point.
I apologize for my statements, and I apologize to Ms. Sullivan for my statements. But what I don't apologize for is what is going on here.
Just one moment. Counselor Lowry, Counselor Lowry, just one moment. Ms. Sullivan raised a point of order. The chair was about to recognize her to state the point of order. I'm happy to continue having you make appropriate remarks, but I do want to show the respect to Ms. Sullivan of letting her make whatever point she was going to make. Ms. Sullivan. All right. You withdraw the point of order? Okay. Councilor Miller, I'd be glad to recognize you. Councilor Lowry, do you have any further comments for council?
Do the work.
Thank you, Councilor Lowry. Ms. Miller,
yes, I would like to say something.
please.
I am not rebutting what you said, Council, but you have to give respect in order to gain respect. And in all due process to all the city employees, I respect all of them. But when you approach some of them with an attitude, I think we deserve respect as council members, just like they deserve respect for employees, as an employee of the city. So it go both ways. And some of the accusation or statement that was made, especially about Fling, we contacted him, and I want the records to show, we contacted him. He said that he would be out of the country during the holidays and to get in touch with one of his paralegals. When we came to this meeting on the 23rd, she was here, what's her name, Bozeman was here. I didn't know who she was, but we was in the process of going on with what we had and what we produced. And we are not upset with anybody, but if transparency had been taking place all along, communication would have been informed in the council member of what's going on, we wouldn't be here. But a lot of misinformation have been given tonight, have been read tonight, and was not factual. That's all I got to say.
Ms. Miller, I do want to point out, just for the sake of clarity, the city attorney role was appointed to Pope Flynn, the firm, while Lawrence Flynn is typically our main point of contact. The firm represents the city, and Jenny Bozeman, C.D. Rhodes, and Lawrence Flynn have dealt with the city on a number of matters since council appointed them. With respect to council's access to legal counsel, I do also, just for the sake of clarity, want to point out that individual council members do not have authority to reach out to city council member, to the city attorney, and incur cost on the part of the city acting outside of a vote of the body. No individual council member has individual authority. It is basic black letter law that the authority of any counselor is exercised when they act as part of the whole through a decision made at a properly noticed public meeting. And if, for instance, there was a vote taken to say, we instruct the city attorney to prepare an ordinance that says X, and that vote was taken at a public meeting, that would be proper. But it is not proper for an individual council member to reach out to the city attorney and direct the city attorney as if they were that individual's personal counsel. I just wanted to make sure that was clear for the public.
I got to say something.
Ms. Miller?
If that's the case, everything that we do, we have to go through you in order to contact the attorney. Is that what you're saying?
No, ma'am. As the executive, in order to guide me in my duties, I do have the ability to reach out to the city attorney for legal advice. But members of council could get together at a publicly noticed meeting and say, we think that there need to be greater measures for oversight and accountability in place. And city attorney, we would like you to prepare an ordinance for us which lawfully puts those measures in place. And even if I didn't like that, a majority of council could direct the city attorney to do that. But that is entirely different from members acting on their own, in which they have no authority as individuals to direct the city attorney to do stuff. If that were the case, it would allow any member of city council to have a whim about things that they would like to do and drive up enormous legal bills just because they thought that that would be a neat thing to ask the attorney to do.
And I want the record to show that Alicia is not acting on her own. It's the four of us.
Are you stating on the record that you all have taken action outside of a public meeting?
No, I'm not saying that. I said, but in support of what is being said, just like this right, the agenda and whatnot. When you said we came to City Hall, it just so happened we all came there to give to Leslie
You just so all happened to show up at the exact same time.
it was the agenda that we wanted, the agenda that we wanted.
And so there was a
And we
discussion
had
among
notes,
some,
We signed it.
and so there was a
Point of order.
discussion among members of
Point
city
order.
council.
Point of order.
Yes,
Point of
Counselor.
order. Let's bring this back.
What is the point of order?
The point of order is that I want to address,
Counselor Whitmer, what is the properly stated point of order?
point of order is, I'm seeing this getting off rail here, and it's going outside the scope of what need to be addressed here.
That's not a properly stated point of order.
We want to bring everything back to our original agenda.
Ms. Miller,
Our
would you,
original agenda.
Ms. Miller, would you cede the floor to Counselor Whitmire to make any remarks? Counselor Whitmire.
It's been a lot of slinging here. Yeah, I know. Yeah, I guess you say no kidding, guy. Mr. Laurie, in most cases, I don't say a whole lot when a female is being attacked, and I feel that she's been attacked from a personal standpoint based on what your actions tonight. Now, we granted you the opportunity to speak in a remote location, as you put it on the floor. And I was offended, as a man, I was offended that she was attacked like this. I know that frustration takes place, but I felt that was out of order.
Counselor Whitmire, with all due respect, I have brought the meeting to order. I ruled Counselor Lowry out of order. He apologized for it. the matter before us is debate of the ordinance. Do you have any substantive debate on the ordinance?
I'm requesting a response to a direct
Wait.
statement made toward me by Mr. Whitmire.
With due respect, Mr. Lowry, I'd like to move on to keep us corralled to the debate of the ordinance itself. Mr.
I understand, Mr. Mayor, but it is clear that my statement, what I outlined, my statement to Ms. Sullivan was out of order. I agree to that. I did that because I couldn't get a sentence out before it was out of point of order. And so I didn't do that to Ms. Sullivan, and that was why it was caused, Mr. Whitmire. You need to remember that. You can look back at the tape and see what caused it. It wasn't mine. I didn't attack her. I didn't attack her until all it was point of order, point of order, point of order. I don't know where she learned that, but
Okay.
that ain't the way it works.
Council, I want to try to keep us on track here and focused on the actual debate of this ordinance. And I'm not directing that you, just, I'm saying that council as a whole. Mr. Whitmire, what is your, do you have any, you don't need a point of order, just what
We're gonna move
do
on
you
to-
have to say about the
Can
ordinance?
we move on to to the voting of our
Yes,
reading,
let's
please?
move on.
Of the ordinance. Can we move on to what the purpose, the voting of the second reading? Can we move on?
I'd like to say one last thing.
Well, Mr., just one moment, Mr. Lowry. I have not heard from Councilor Bolt. I want to just recognize him since we have not heard from him. You don't have to, but I just want to.
Yes, I would like to respond. I think this has been one of the most ridiculous meetings that I've been on the whole 4 years I've been on council. I've never seen anything like this before in my whole 4 years. And, I'm surprised to see this council this far off of one another and in this condition. Ms. Miller and I have been friends for all 40 years. And I hope we still are. But I think this meeting was uncalled for during this time, during the holidays. And I have not, said a whole lot. I know what's going on here. I know, but, there's some people behind this thing that's behind the board. I don't know what they're saying, but I think, there's been some misleading. And we should have been able to sit down and talk about it and handle it in a personal way, rather than have to come to this particular point. And so, I just hope we can go on. I don't know what it's gonna take, but, I just hope, pray that we can come back and be a meeting and be in one accord. But, I've never seen anything like this in my 40 years on the council. And so, it's been a total shock to me that we had to go this far with this without having just be sit down and talk about it, because it could have been handled totally in a different way. And I think they know that, and I think we know that. But yet it's been pushed out to the public, and now it's got our whole city in a turmoil. We've never had this many people attend council meetings. And they're here because they're concerned. They're here what's going on out there. And they don't like it. And they got their own opinions too. And so it's just brought our whole city interrupted. And that's all I got to say.
After Mr. Lowry speaks, may I speak again, please?
Certainly.
I just want to put that out there.
I'll yield to Ms. Cassandra.
We, through the conversation that we've had today, we've spoken about the allegations that have been brought before us. Those allegations were not just brought to 4 people. And I, as a citizen and as a person who has been voted in to represent our citizens, would feel like I was not in order and not respecting my responsibilities and the humanity of the people that we're serving if we did not move forward as we have. And if it were just as simple as coming together and talking it through, we would have done that. But the allegations, again, were brought before all of us. Yes, they were.
What allegations?
Okay. Okay. I yield. You're not in the blind.
No, I'm in the public. You're right, I'm in the public and I'm out speaking, and I want to know what are the allegations? Please.
You're
give
not
us
in,
one.
you're not in the blind.
I'm not in the blind. That's an allegation?
I yield my time.
Okay, well, then, all right, it's my turn to speak. I don't understand, because I haven't seen any allegations. I mean, we weren't even getting, the proper documents, Johnny and I and Nathan, they weren't sent to us. We get them through Leslie, I get it. But this is what I really want to talk about, is that I respect what Johnny has to say, and I respect Ms. Miller very much. They've been on council a long time. And what I wanted to say is that there is an off-ramp on this whole thing, and I hope each one of you will think about it. Our attorney, in writing, offered to conduct a workshop with all of us, to sit down and talk about all these issues, the things that we want to move the city forward. Many times, there's people on this council that have asked for workshops for different things. Now our attorney is offering one. And I'm putting out an olive branch to everyone to put this thing aside and let's sit down and talk about it. Ms. Miller, I talked to you a little bit at one point a while back, and you expressed your frustration with transparency. And I get it, and I told you that. I think we'll get that going forward, but I don't think this is the way to do it. I don't think slinging mud is the way to do it. The way to do it is for us to sit down in a room and hash it out. And we can have an impartial, this is not me versus you, this group versus that group, Nathan versus the council. We could have an impartial moderator in the form of an attorney sitting in a room, and we can hash out any problems there are. Anything. I've yet to know what the allegations are. I'm asking for them.
Did you not get your packet from Leslie or from, we know that you weren't at the last meeting, but you got the information that everyone else got.
Ms. Campbell, but there's a mismatch between what is being said publicly, that this is just an insurance policy, this is just car insurance, versus apparently credence given to allegations without even having an opportunity to speak with me and others who might have some response. But putting that aside, any and all information that you're referring to has already been referred to SLED. This ordinance, the ultimate outcome of this ordinance is to say there needs to be an investigation conducted and send anything that needs to be sent to SLED or the Ethics Commission. Well, it's already been done. The ordinance is not necessary to do what the ordinance attempts to accomplish. And because of the way that it's been done, because you have a direct violation of our local ordinance 2-94, which says that it must be approved by the city attorney, and he has stated in writing that the ordinance itself violates our own laws. If it were challenged in a court, and it will have to be, and the expenses will be incurred to challenge it, it will be struck down. So what is the point? What is the point if we're going to if we are already at the place we would get to anyway? This does nothing to serve this city. I respect the instinct to pursue transparency and accountability and better communication. To that end, I called a special meeting of city council for executive session as soon as I had information to share it with council so y'all could be aware. I have repeatedly reached out and asked for the opportunity to sit down with you and answer whatever questions you have. If the goal is communication and transparency, you have had the opportunity. If the goal is oversight and accountability, that is being done. All this does is run up bills for the city and make it less likely that the people who are working hard every day get the pay that they deserve because we'll have spent money on legal fees rather than salaries. I don't understand it. And I will just say, as a personal matter, what I'm so confused about is I have had such close relationships with each of y'all.
We still do. Why not? Why we don't? I'm not upset with nobody. You?
If nobody's upset with anybody, then I would ask as a friend, if you have any concerns, let's talk. We can table this ordinance, and before we subject the city to legal liability, how about we just sit down and have a chat?
Yeah, we friends, but we still have a job to do as a council member.
Absolutely.
That's separate. So let's move forward.
But by taking this action, you go down a road for which there is no off-ramp.
Okay.
And that is the exact advice given to council by independent legal counsel. It is not, access to legal opinion is not the problem here. It is the refusal to abide by legal opinion. You've gotten all the legal opinion you need. Just listen to them. Is there any further discussion?
Mayor, I'd like to say one thing.
Yes, Mr. Bolt.
I know that, they have reached out to people to get where they got their information. Have they reached out to you to get your information? You call, I know, one employee contacted every one of us. Not dealing in personalities, contacted every one of us. I know some of you, of the council members, reached out to that employee. They got that side of the story, if I'm correct. You reached out to them and asked them to call you. Could you do a poll, see how many called you?
Not one person has responded to that other than you.
Mr. Bolt, we had an executive session with the mayor concerning his side.
No, ma'am. That is not the case.
I haven't had a
And
discussion.
we
with
can't
nobody.
discuss what we talked about in executive
I
session.
didn't say I was gonna discuss what we talked about in executive session,
Well,
but
I'm
we
talking
had
about-
one,
Okay,
and we talked
Miss Sullivan,
okay.
That,
I'm
Councilor
talking
Bolt.
about, since this came up, since the last meeting, we were all in one accord, like a Honda, we were all in one accord.
we were.
We were, in the November meeting. We came back to December meeting, and we were all going down the float. Something changed. An employee left the city.
Did you talk to everybody?
Huh?
Did you speak with everyone?
I started to, but I chose not to.
Okay.
Okay, but,
I raised my clip, that's all I need to hear.
But I did get some input. But y'all didn't reach out to the mayor either. But anyway, that's it.
That's it.
There's always two sides to every story.
It is, but you
And
got to
my
hear
side
both,
is
you
three.
got to hear both too.
I welcome the
I
opportunity to
got
share
a
my
letter.
side.
I got
but
a letter.
I told the mayor at the
I got
last
a
meeting
letter.
that he sent that text, I did not receive that. He showed it to me on his phone, but I took care of my phone back, it was not in mine. So as far as what he sent out to you all, I did not receive.
And I haven't been getting
Okay,
texts
all right.
either, so.
All right.
Ms. Miller,
I do.
Ms. Miller, I just want to state for the record, I'd be happy to sit down with you anytime you dignify me with the opportunity. And I make that offer to any one of the four who's apparently supporting this ordinance.
And it was something else I wanted to say, what you said, Johnny, because at the November meeting, because of, the former employee, that is not true. As far as the, former employee no longer here is former administrator. So, this meeting did not come about, because of that. I want the record to show that.
Well, there've been several employees.
Thank you, but I just want to say that, because you, it been stated several times.
I would like to make clear, once again, not only do I respect council's impulse for transparency and accountability, that be comprehensive. And I understand that there have been frustrations about communication or lack thereof. And that is a subject for some good communication. I think what Councilor Lowry proposes, what the city attorney suggests, in having a workshop where we could receive legal guidance would be a sound decision and would potentially avoid a costly process to the city. Is there any further discussion?
Got one last statement.
Councilor Lowry.
He spoke more than twice.
Point of order from Ms. Sullivan. Councilor Lowry, you did have spoken more than twice. I believe that we're at the point where we need to call the question.
All right, don't spend the money, too much money, wasting money.
All those in favor of passage of ordinance 12-22-25, please indicate by saying aye. And this will be by roll call vote for the record. Councilor Bolt.
No.
Councilor Lowry.
Absolutely not gonna waste the money of the city that we can't afford.
Councilor Whitmire.
Yes.
No.
Yes.
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 Let the record reflect that those councilors supporting this ordinance were Whitmire, Campbell, Sullivan, and Miller. Let the record further reflect that these members are taking action outside the ruling of the chair, without legal authority, without compliance with section 2-93, and contrary to the legal advice issued December 23rd and December 30th of City Council, the city's legal counsel. The chair will not certify or sign any ordinance adopted in this matter, and therefore this matter will require judicial resolution. There being no further business before this council, I now call for a motion to adjourn.
As being Mayor Pro Tem, I would like to make a motion to adjourn.
We have a motion. There's a second. Without objection, we are adjourned.